So, hello everybody. Today we also are going to talk about the articles of the CIG, and the article for today is number 7. So, it promotes uniform interpretation and the application of the convention, ensuring that it is interpreted in light of its international character and the principle of good faith in international trade. It also provides some guidelines for resolving issues not explicitly covered by convention, by referring to general principles on which the CIJ is based, or in their absence, to relevant domestic law determined by private international law rules. So I found some commentaries on this article, and the first commentary would be from Svetzner and the Schlechtreim. They highlight the autonomous interpretation. So here they telling that the CIG should be interpreted independently of the domestic legal system to maintain consistency and avoid national biases. Another commentary was from the Stefan Kroll, and here he highlights the uniformity and the good faith here, and he said that courts should consider foreign decisions to promote uniform application and to foster good faith in international trade. And my last commentary that I found, the nuance of it was from Secretariat of Commentary, and he said that issues not covered explicitly should be resolved using CIG general principles. If these are not sufficient, domestic law should be applied as a last resort. So I found some cases here. The first case was about the Spanish buyer and the Belgian seller. The name of the case, Lava Meat NV versus Jamones Velázquez. And that was in the Spain, in the Audience Provincial de Zaragoza. I mean, the Court of Appeal of Zaragoza. And the decision was made in the 2009. So the dispute involved a Spanish buyer and the Belgian seller over pork shoulders that allegedly didn't meet the required standards for producing this ham. So the Article 7 was crucial because it emphasizes the principle for good faith and uniformity in interpretation and application of CIG. So the court used the Article 7 to highlight the buyer's obligation to act in a good faith by notifying the seller. Another case was also in Spain, in the Barcelona Provincial High Court. And here, the Italian seller sued the Spanish buyer for unpaid goods. And the Article 7 was crucial for interpretation of the convention and to emphasize some interpreting the CIG with regard to the international character. And my last case was in the Netherlands, where the GG company versus Avril SRL. So here the Netherlands buyer versus the Italian seller. And the interpretation of this convention was given by Article 7, and it was crucial interpretation to that the buyer's appeal to reject the seller's claim based on the reasonableness and fairness, and it was denied. And the provision 1 of the Article 7 CIG doesn't allow deviation on such grounds. Yep, thank you for listening to me. That was
Okay,
very
thank
good.
you, yes. And I want to present some commentary by the Michael Joachim Bonnell. And he says that despite the necessity to interpret uniform laws autonomously, in general, an exception must be made if it turns out that with respect to a particular provision, there exists an insuperable conflict of interpretation between the contracting states. To insist even in such a hypothesis on an autonomous approach seems to be unrealistic, and in practice, the result could easily be the opposite of what was desired. That is to say, that courts in each country could feel free to apply their own national interpretation, irrespectively of the circumstances of the single case. It is much better to acknowledge that with respect to the specific issue, so uniform law failed, at least for the time being, to bring about uniformity in the laws of the contracting states and to accept as the only possible remedy the recourse to the traditional conflict of laws approach. And after all, by applying the interpretation prevailing within the state, the law of which would govern the transaction in the absence of a uniform law, it may be hoped that the solution will be the same irrespective of the forum chosen by the parties. And another commentary I found from the Schlechtrim and Schwender, and they say that the reference to the international character of the CHG indicates that the character of its rules must be borne in mind when applying any method of interpretation. It embodies the principle of autonomous interpretation. For example, the meaning of the terms used by the convention must be determined independently from any domestic preconception, and the solution developed must be acceptable in different legal systems with different legal traditions. I found some case in Russian courts, in International Court of Arbitration of the Chamber of Industry and Commerce of the Russian Federation. Yes, it might sound not so reliable, but actually it is. It happened in 2008, and there a claimant, a Russian company, entered into a contract with respondents, a Moldavian company, for the supply of natural gas. And according to that contract, the gas was to be delivered in parts to the respondent itself and in parts to a third party. We can call him the recipient. Although the recipient was formally not a party to the contract provided that the recipient should pay for the gas directly to the claimant. Nevertheless, when the recipient failed to pay the price for the gas received, claimant requested payment of the price not from the recipients, but from the respondent, the Moldavian company. And when respondent refused to pay on behalf of the recipient, claimants filed a claim against the respondents before this court. And of course, tribunal rejected the claim for the following reasons. First, because claimants, notwithstanding the fact that respondent had repeatedly informed claimants about its unsuccessful attempts to have a formal commitment from the recipient to pay the price, they accepted to deliver the gas directly to the recipients. And second, and more importantly, because claimant did not comply with the requirements of pre-arbitration dispute settlement procedure as provided in the contract. And according to the tribunal, claimants in both respects failed to act in accordance with one of the basic principles of international trade and of the law itself, the principle of good faith, as laid down in general terms in Article 1.7 of the UNDRA principles, and of course in the CHG, in the 7th and 8th articles. And I think I won't I can't tell about the other cases because we have time. So thank you for listening and goodbye.
Yep, thank you for good conversation, Timerlan. Yep. So see you in the next videos.